Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-7132 et al. Christiana Tah and Randolph McLean appellants versus Global Witness Publishing, Inc. and Global Witness. Mr. Smola for the appellants, Mr. Bowman for the appellees.
Good morning. Good morning, counsel. Mr. Smola, we'll hear from you when you're ready. You need to unmute yourself and you can proceed.
Good morning, Your Honors. May it please the Court. I am Rodney Smola on behalf of Christiana Tah and Randolph McLean. Your Honors, this appeal is more about the integrity of the federal rules than about the First Amendment. The district court below analyzed all of the issues pending in this case and ruled in favor of Tah and McLean on all of them except the final one, the actual malice plausible pleading question. And I'll focus my initial attention and most of my attention in this argument on that final issue. The question before the court is whether the complaint plausibly alleges actual malice, as that term is defined by the various First Amendment standards, and as that term is defined, as the word plausible is defined by the landmark decisions in Bell Atlantic Corporation versus Twombly and Ashcroft versus Iqbal. Twombly and Iqbal tell us that the word plausible means more than a possibility, but less than a probability. But more than that, Twombly and Iqbal are very articulate in describing the sorts of things that will not do and the sorts of things that will push the plaintiff over the plausibility line. So what will not do? What's not good enough? Threadbare allegations are not good enough. Legal conclusions are not good enough. Formulaic recitals of the elements of a claim are not good enough. And the mere invocation of buzzwords is not good enough. So what will do? What is required? Well, what's required is that the plaintiff set forth sufficient factual detail that the legal elements of the claim might plausibly be proven. Critically, it's not necessary that the complaint prove the allegations. Of course not. It's not necessary that the complaint even show that there's a probability that the allegations would prevail. All that's required is a probability. And we think on this score, the district court below simply analyzed the case through the wrong prism. I want to commend to the court two very revealing sentences in the district court's opinion that we think show the mindset that got off the track here as the district court analyzed the complaint. The first comes at the very beginning of the district court's analysis of actual malice, and the second comes at the very end of that analysis and the very end of the opinion. The district court said at the beginning, and I'll quote it directly, quote, "Without more than is mustered here, there is not clear and convincing evidence that Global Witness was aware that its story was fabricated or too improbable to fabricate." And then at the end of the opinion, the district court says, "Without clear and convincing evidence of actual malice and only strands of evidence, plaintiff's pleadings fail to meet their burden." Well, that is the sort of language one would have expected on a ruling under a Rule 56 summary judgment motion.
Mr. Small, why don't you focus for us on which allegations in the complaint you think are the most significant in terms of meeting your burden of proving malice or alleging malice?
Your Honor,
instead of focusing on the district court's language, tell us which allegations should we look at that you think satisfy your burden of adequately alleging malice?
Your Honor, the overarching theory of our complaint, buttressed by multiple allegations, and I should say, Your Honor, in 20 paragraphs and 8 pages of text in the complaint, the arching theme is that from the very beginning, Global Witness was fixated on a story that was going to be alleging that Exxon facilitated or was complicit in bribery. And it did so when Rex Tillerson, who had now become Secretary of State under President Trump, was in control of Exxon.
Well, isn't that the way investigative journalism works? They start out with a hypothesis.
And of course, that's true, Your Honor.
Yeah.
However, it's our submission that if that hypothesis was the sort of hypothesis that was so predetermined and so fixated in the journalist's mind that they turned a blind eye to any contrary evidence and engaged in deliberate avoidance of the truth.
Okay, so what is it that suggests that this was not a legitimate hypothesis but a pre-confirmed view, that they had their view before they began their investigation? What allegation responds to that? Mm-hmm.
Your Honor, we point to multiple things that support that. And again, we don't have
just tell us two of them.
The first, Your Honor, is the letters that came a week before publication that went to my 2 clients, but many other persons involved in these events, as well as to the consultants who had analyzed this entire deal, in which the journalist says unequivocally, "We think you've taken bribes." Now, Your Honor, that could cut in 2 directions. That could have an inculpatory inference that this is a continuation of this fixation and it had been made up from the beginning and that they were blind to anything that would counter that. And it could also have an innocent explanation, that they'd done their homework and now we're going through the motions of contacting the persons that were going to be targeted before they published. Our point is,
but if this is standard, isn't this also standard investigative journalistic practice that at the end of an investigation, the journalist or the journal in this case contacts the target and says, "Here's what we think. This is what we think we found. Do you want to respond?"
Your Honor, yes.
If we're a rule in this case that these letters are fall on the wrong side in terms of your view here, then reporters will be taking a huge risk by writing a letter like this, won't they?
Your Honor, we contest that, and we contest that because although that principle may be accurate ultimately after a fully developed record, the prior decisions of this court that articulate the thoughts that you've just described, Your Honor, all came after the plaintiffs had the benefit of a thorough investigation and a record. So if you look at the cases relied upon by Global Witness, relied upon by the district court, Tabula Reyes was after a jury trial. Lawrence versus Donnelly was after a fully developed record on summary judgment. Yankovic 3 was after a fully developed record on summary judgment. And
Counsel, you agree that the standard that you have to meet is set forth in the lens. There's obvious reasons to doubt the story. Isn't that correct?
Yes, Your Honor, and I was the plaintiff's counsel in Lorenz, and and as you know, in that case, that was elaborately developed in summary judgment, and the court ultimately ruled that despite all the notes, despite all the sources, despite all the references, we hadn't met the burden. And we think that what's key here, Judge Silberman, is the distinction between the standard on a Rule 12b6 motion and the distinction between the standard on a motion for summary judgment. And Buzz,
I'm not even sure you have to make that argument, counsel. What are your obvious in your allegation? In your complaint? What are the obvious reasons to doubt? that you assert the defense labored under? What are the obvious reasons to doubt?
Well, among other things, Your Honor, the elaborate explanation by those that Global Witness contacted as to why it was utterly implausible that these were bribes. The fact that the money went to hundreds of people, all the way down to the custodial workers. The fact that the decision to initiate the payments was because this was a landmark deal for Liberia of the sort it had never had before. That the direction came from President Sirleaf, this Nobel Prize winning president, first person who was a woman head of state in Africa. There were many indications that this was a bad.
Excuse me, counsel. What do you make of the statement that you refer to in the complaint? The Global Witness has no evidence that Exxon directed NOCAL to pay Liberian officials, nor that Exxon knew such payments Exxon even knew such payments were occurring.
We think that statement helps us tremendously, Your Honor, because we think it's speaking with a forked tongue. On the one hand, what is overwhelmingly communicated here is that they've got the goods on Exxon and they've got the goods on these officials and they did it. And then they admit in the very same document they don't know whether they did it. And so they write a story creating the impression this is bribery, this is bribery, this is bribery. That's how we want you to see this story. But then they explain, well, we're not sure. And if you convey the impression...
No, it's worse. Isn't it stronger than that, counsel? We have no evidence. We have no evidence connecting Exxon to the money paid, incidentally, to 11 people, 6 members of the committee and 5 consultants.
Absolutely, Your Honor. It is stronger than that. And I think that is in itself enough to cross the threshold required by Twombly and Iqbal. It is at least plausible, given what they have said themselves, that this was communicated with reckless disregard for truth or falsity.
So can I ask you a following question? So if all we have in a complaint is an allegation that the publisher said something like, we believe you may have committed bribery, and then there's a vehement denial by the people to whom the correspondence is directed that says, no, that's absolutely false, that's not what happened. Is that enough to get past the pleadings?
No, Chief Judge. I think that would be the kind of formulaic recitation, the kind of threadbare allegation. And it's our submission, obviously, that that's not our case. That we have all these other indicia. We have the fact that, curiously, although they accuse the consultants of bribery, they drop out of the picture. Although the advisor to the president, someone who would be sort of akin to a White House counsel in the United States, who had approved the deal, he doesn't show up in the final allegation. There are all these different pieces, and as we have strongly urged, in any defamation case, these are all that most plaintiffs will ever have at this early stage, before they can look at emails, before they can look at text messages, before they can depose sources, before they can examine the journalists, before they can see the earlier drafts, before they can see what the editor said to the journalist, this might be a good story to go forward. So even as Your Honor has said, there may be some element to this that tracks routine journalistic practices. There's also a pattern here that tracks the way defamation cases operate in the real world. And we think that there's no fair characterizing our opinion as threadbare or relying only on buzzwords. It's factually laden. It goes deeply into everything that's in this Global Witness report and the inferences to which we are entitled. Just as in baseball, when tie goes to the runner, in a case like this, if there are multiple inferences possible, we must get all of them at the front end. Your Honors, I've spent all my time on this issue, and I know that there are many others, and I know you'll hear from my friend Mr. Bowman on many others. I do want to say at the front end, and I'm sure I'll have a little bit of chance to talk about this on rebuttal, that On the SLAPP issue here, we think the case is extremely simple. There is simply still today a dissonance between the standard under 12b-6 and the standard under the District of Columbia anti-SLAPP law. Under the anti-SLAPP law, the plaintiff must adduce evidence to defeat the SLAPP claim. Nothing like that is required under Rule 12b-6. In fact, it's not permitted. And under the anti-SLAPP law, the burden shifts to the plaintiff once the prima facie case is shown, the exact opposite of the burden in defeating a Rule 12b-6 motion. So this court's prior panel decision in Abbas was not superseded by Mann. It remains the law of the circuit, and this court ought not revisit it.
Can I just ask you one question on this anti-SLAPP issue?
Yes.
And we will give you some time for rebuttal. You haven't taken a position in argument today or in your briefing that we don't need to reach that issue. Your point is just on the merits that if, assuming we do reach the issue, that you ought to prevail and the anti-SLAPP statute is not properly before us because of Abbas.
Actually, Your Honor, I think we take both positions. We say very forthrightly, we don't think it's appropriate for the panel to entertain the issue because Abbas is the binding precedent of this circuit. Now, the other side
that is entertaining the issue. It's just that Abbas resolves it. The
Abbas resolves it. I think the two effectively come together because there is this narrow band of exception that says if there's an intervening decision that absolutely abrogates a prior decision, a subsequent panel may be permitted. But if there isn't, if Mann does not constitute that, then Abbas remains good law. So the merits and the power of the panel, I think, Your Honor, in effect, come together.
I guess what I'm saying is what's at stake for the other side on that issue is the possibility of obtaining attorney's fees. So one could make the argument that if that's what's at stake, then there's no need to reach the issue at all. You're not taking that position. You're saying reach the issue, but then rule in our favor because Abbas, however you say it, is still governs. You haven't made that argument.
Just to be careful, Your Honor, we do say we don't place great emphasis on it, but we do say that even if we're wrong on the merits and you were to overrule Abbas and say that the SLAPP law applies, the court ought to use its inherent authority to announce that prospectively, because clearly it would be a terrible trap for the unwary for us to suddenly be saddled with attorney's fees when we forthrightly admit that we chose the federal district court forum because we had been led to believe by many district court opinions and this court's opinion that the anti-SLAPP law did not apply.
Counsel, weren't you asked to address the question of standing on the part of the defendant's cross appeal?
Your Honor, and we don't contest that they have standing. So I'm
a little puzzled why nobody contests because the Supreme Court has specifically said in Steel Coat that attorney's fees are not injury in fact.
Your Honor, we'd be delighted for you to follow that line, of course. I think the reason that I'm hesitant to contest it is they clearly get a tangible procedural advantage in the case if they get the benefit of the and I think a party probably has standing to say I'm entitled to that, but that's the very reason we should win, because if they get that tangible procedural benefit, by definition, it's inconsistent with the federal rule.
Actually, I really don't care what the parties say, because that's a matter on which we have to rule independently. If there is no injury in fact, there's no grounds for cross appeal here on the part of the defendant. But let's go on, because it may well be unnecessary to even reach the SLAPP statute.
I appreciate that, Your Honor.
Okay, thank you. Unless my colleagues have further questions for you on your opening argument, Mr. Smolla, we'll let Mr. Bowman go, and then you'll get rebuttal time. And just to outline the procedure, since there is a cross appeal, you'll both get a bit of rebuttal time.
Your Honor.
Mr. Bowman.
Chad Bowman on behalf of Global Witness and Global Witness Publishing, Inc. May it please the court. This is a defamation case brought by two former senior librarian officials against a nonprofit organization that published a white paper, a nonprofit organization that has a long history of working with the librarian people to increase accountability of their government.
Counsel, may I suggest, because there's a limited time, that you go immediately to the actual malice question, assuming arguendo that a libel has been made out. I wouldn't be surprised if the three judges are most interested in the question of actual malice.
Yes, Your Honor, of course. We don't dispute in a 12b6 motion that the tie goes to the runner. Our position is this case does not pose anything close to a tie. In this case, the district court looked at the pleaded allegations of actual malice in the complaint and asked the question, do those pleaded allegations, assuming the factual allegations are true, plausibly establish actual malice under the standards of this court, as set forth by the Jenkovich court, the Lorenz court, and all of the decisions in this court recognizing the high burden that a plaintiff has to meet. And the court said no.
To ask you a question about Lorenz, which I said, you agree. The question is, are there obvious reasons to doubt the story? That's the standard in Lorenz, right?
Yeah, it's one of the Hart-Hank standards, yes, Your Honor. If there are obvious reasons to doubt a story such that there is a high degree of awareness of probable falsity, that would be actual malice.
All right, good. So in terms of asking whether there's an obvious reason to doubt, you have a mixture of objective standards and subjective. The obvious reasons to doubt is an objective standard leading to a conclusion about subjective motivation.
I think it's a subjective standard, Your Honor.
No, of course, but you
have subjective reasons to doubt.
Obvious reasons is a objective standard.
Yes, Your Honor.
Okay.
What I think is important here to remember and to emphasize, and I don't mean to move off actual malice, but this report, 35-page report with 125 footnotes, the plaintiffs don't cite any false facts in the report. Everything published in
now you're sitting on the question of
yes.
Lie, and I suggest to you that you should focus on actual malice.
Yes, Your Honor. So with actual malice, we're talking about an awareness of likely falsity of an inference. You have here the allegation from plaintiffs that...
Excuse me. The standard is obvious reasons to doubt.
Yes, Your Honor.
That's the standard in Lorenz.
Yes, Your Honor.
Were there obvious reasons to doubt or not?
No, Your Honor, there were not. And in fact, plaintiff concedes that, or the plaintiffs concede that in their briefing when they say that the global witness published a report raising the question not knowing whether it was true or false. They investigated whether or not these admitted payments, these bonus payments that were received by these officials that were larger than their annual salary following the completion of the transaction were legal. They asked the contact
counsel, you're referring to page 48 of their brief?
I'm referring to page 15 of their brief, Your Honor.
Well, it's also on 48. In other words, former Liberian officials concede that Global Witness did not know whether the payments were illegal. That concession alone negates the possibility of sufficient actual malice pleading. That's your point?
My point is we read that differently. That concession by the appellants here concedes there wasn't a subjective awareness of falsity. The report itself said, here are all the facts.
Actually,
I don't know whether or not this rose to the level of bribery. There should be an investigation. We are raising that as a question.
Excuse me, counsel. If you look at page 36 of the brief, it states Global Witness subjectively knew that it had not been able to determine whether the payments to Tah and McLean were corrupt bribery payments. If that had been all they said, you would be right. But if they go on to say, yet without resolving that subjective doubt and notwithstanding the material in its possession that generated a high degree of subjective awareness that the story was false. So in other words, they go beyond your contention. They say you didn't know, but you ignored evidence that the story was false.
Your Honor, we dispute that there was evidence. Global Witness contacted each of the sources.
I'm only making the point that they didn't make the concession that you said they made.
Yes, Your Honor. Our point, Your Honor, is that the allegations will take into three buckets. The allegations of a preconceived narrative. This court has been clear in the Jankovic decision, a preconceived narrative is the nature, as Judge Hadel mentioned, of investigative journalism. You go out and you test theories. A preconceived notion, an allegation of a preconceived notion of a story, is only evidence of actual malice if it's coupled with facts that plausibly suggest that someone wanted to fulfill that preconceived narrative through falsity. There's no factual allegation here of that.
Wait a minute, counsel. I agree with you that preconceived notion is not the strongest part of their case. But what is more, it seems to me, a lot stronger is the fact that you specifically say Global Witness has no evidence that Exxon directed NOCAL to pay Liberian officials, nor that Exxon even knew such payments were occurring. Now, I realize you put that in order to rebut the libel action, the first step. But it seems, why isn't that injurious to your position on actual malice?
Our position is actual malice requires an awareness of subjective falsity, Your Honor.
Well, okay. You have, let's assume, arguendo, that the first step is made out. There's an implication of bribery. Now, in which case, who are the bribees?
The bribees would be the individuals who received the largest payments and voted for the deal.
And why would that include the consultants who got $15,000 apiece?
You're speaking about the omission. The report is clear. It says it names the individuals who voted for the program. There are many more who received bonuses. Including the consultants. But it names.
All right. I see your point. So there's 6 people who are the bribees, right?
In your hypothetical, Your Honor, yes.
Well, no, it's your case, isn't it? The 6 people are the bribees, right?
Our position is that Global Witness asked a question and called for an investigation.
No, wait. You have to assume, for purposes of my question, you have to assume the first point has been made out the way the district judge said.
I accept that, Your Honor, assuming that to be the case. Yes.
Okay. Now, the bribees are 6 people, at least 6 people, right?
Yes, Your Honor.
This is all quite public, right?
I'm not sure I follow that.
There's no secrecy about this.
There's no secrecy.
That's right. These 6 people got $35,000. It's also true that you have 0 evidence that Exxon had any knowledge of these payments.
I say no secrecy, Your Honor. There's no secrecy because a Liberian good government law, which Global Witness had helped champion, required the publication of that information. And the point of this report was to encourage the publication of similar information in the United States so that we would have access to.
You're avoiding my question. The bribees are at least the 6 individuals who got $35,000.
Correct.
It's undisputed, according to you, that there's 0 evidence that Exxon had any knowledge of these payments.
Global Witness included in their report that they did not have evidence of that payment, which is why they called for an investigation.
All right, wait a minute. Now, if you're alleging bribery, which of course is the first step, we're assuming arguendo, then the bribees are this 6 people. And yet you have 0 evidence of any privity between Exxon and these individuals concerning a bribe. Isn't that correct?
It was not inherently improbable given the history of this oil concession.
Why isn't it inherently probable? This is all public. Bribes take place in the dark of the night.
I think not always, Your Honor. In 2007, the Liberian government investigated and adjudicated that there was, in fact, bribery over this very oil concession when it was privatized.
We don't know any of the facts about how that bribery is determined. But isn't it true bribery is a crime, right?
It is a crime, Your Honor.
You don't normally advertise it publicly and saying everybody got $35,000. It's undisputed that this happened after the deal was over. It's undisputed you have no evidence connecting Exxon to these payments, none at all. So why isn't that per se actual malice? It's inherently. Why isn't there objective reasons to doubt the truth of the implication? It's public. According to your view, Exxon is spreading bribes around like Johnny Appleseed. It's absolutely public, and you have zero evidence connecting Exxon to the payments.
Well, Your Honor, Exxon doesn't need...
But you imply that Exxon bribed them.
Your Honor, Exxon doesn't need to be the bribe payer in your hypothetical. In the 2007 situation, the bribes were not paid by the foreign oil company. The bribes were paid internally to get the legislature to approve.
But didn't your article imply that Exxon did the bribing?
The article asked the question whether it was appropriate for Exxon to provide a pool of money to be distributed to the people who voted for the deal. Bribery, Your Honor, is a conclusion.
Where do you have any evidence that Exxon provided a pool of money to be distributed as bonuses?
Raise the question whether Exxon did. The bonus was paid.
You can't raise a question without any evidence at all. An allegation of bribery without any evidence at all?
Your Honor, the evidence is that the pool of money was paid as part of the 2013 transaction. Following that transaction, a pool of bonuses was paid. The report raised a question based on these disclosed facts, whether or not that was proper, including whether or not that violated bribery laws.
Now you're going back to the original question of whether there's an implication of bribery. Yes. And I've asked you to assume, arguendo, there is an implication of bribery, because that's the first step, right? And once, you see the point, once an implication of bribery, then you have the briber is Exxon, and who are the bribees? There's 6 people who publicly are disclosed as getting a bonus. There is zero evidence that, although there's an implication in your article that Exxon did the bribing, you have zero evidence connecting Exxon to this money.
The money, I'm not sure that's true, Your Honor. The money was paid as part of the transaction, and it was expressly tied after the transaction as for a job well done to the people who worked on the deal. And I take your point.
Under that theory, I as an ex-banker, I can tell you, under that theory, every investment banker who takes a share of the transactions in a sale of a corporation to another would be guilty of bribery.
Slightly different, Your Honor, when they're public servants who are not supposed to necessarily receive bonuses for.
So you think the fact that they got bonuses is per se evidence of bribery?
I didn't say that, Your Honor. It's per se evidence that Global Witness thought it should be investigated. Given the history of this oil concession.
Now you're back to the basic point. Let's assume you implied bribery. If you assume arguendo, you implied bribery, I'm trying to examine whether you have any evidence that rebuts actual malice. Or isn't this inherently improbable, to use another standard, that this bribe would be so public without any indication, no privity between Exxon and these bonus payments? Zero.
May I answer the question, Your Honor?
Yeah, you can. Yes.
I think the evidentiary burden is on appellant to show awareness of falsity here. I take your point that you're asking what affirmative evidence does Global Witness have if you assume it made an implication that it did not squarely make in its report of bribery. I would say the evidence is that Global Witness sought comment. Global Witness included comment. Global Witness set forth all the bases that it understood why it was asking for an investigation, which I believe, taken in the full context of the report, illustrates that potentially corrupt or improper or bribes are not inherently improbable in Liberia when you're dealing with the disposition of state assets like that oil license.
We should just assume that Liberia is corrupt.
I wouldn't say that, Your Honor. However, this particular oil concession did have a history of corruption, one that was acknowledged by Exxon when it proposed a multi-step transaction because it was concerned with U.S. Money laundering laws, given the original privatization of the 2007 concession. And given
that goes back to the first question, whether there's an implication of bribery.
I take your point, Your Honor.
So if we assume you keep taking the point, but let's say you take the point and you can't have the response that you tried to make several times, which is that all you were doing was raising a question, because that does fight the premise of the line of questioning, right? So if you can't just say all we were doing is raising a question and you have to assume that there was an implication of bribery, then do you accept the proposition that if there was an implication of bribery, there were obvious reasons to doubt whether there was bribery?
We do not, Your Honor. Our position is if the Global Witness report came out and said, we think these are bribes, the reasons we think these are bribes are completely set out in the report. Everything from the history of the transaction to the large payments that were unusual. There's no dispute that payments like this had never been made to these individuals. There's no dispute that the legality of accepting these payments was decided by the people who were going to receive them. It's not disputed, it's alleged in the complaint that the person who decided to give to make the bonus, the president, her son received one of those payments. All of those facts are set forth in the report, including the responses of the individuals that Global Witness was going to name as people who both received bonuses far in excess of their annual salary and voted for the transaction that provided the funds for those. Having laid out all of that evidence, if Global Witness had come out and said, we think these are bribes, that's a conclusion. That's a conclusion amply supported by the disclosed facts that lead to that conclusion. And there are no obvious red flags.
Also, you're still back on the first issue. And that's, I think, shows the weakness of your actual malice argument, because you keep coming back to the first question, denying there's any implication of bribery.
All right. The plaintiffs, may I respond to the specific points the plaintiff raised about alleging actual malice, Your Honor?
It's on actual malice, yeah.
Yes, it's on actual malice. The alleged omissions, the district court, I think, properly regarded that as somewhat of a non sequitur, because the report expressly said these are the individuals who both voted for the transaction and received the largest bonuses. The idea that there were others who also received bonuses that were smaller and didn't vote for the report, that is not an obvious red flag that not disclosing that somehow illustrates that Global Witness knew what it published was false. That's the theory on omissions. Their theory on, I think I already discussed a little bit, their theory on a predetermined agenda. Essentially, the fact that Global Witness sought comment from the individuals it was going to report about is being spun as somehow they knew it was false. They asked, they said, this is what we believe based on the information we have. What is your response? In light of that response.
A little stronger than that. It was an accusation, wasn't it?
I think the actual language of the letters, Your Honor, is we believe this is likely bribes under Liberian law. How do you respond?
That's what I call an accusation.
And Global Witness took those responses, decided ultimately not to make the allegation in its report, and also included the responses and the explanations by those officials in the report. I don't think that's probative of a high degree of awareness of probable falsity. That's probative of an intent to portray fairly a complex factual situation, a situation that Global Witness struggled with. So you have the omissions, the alleged omissions, the alleged preconceived narrative. I think that's essentially what the plaintiff has, other than this idea that it's inherently improbable in the disposition of a Liberian oil asset. It's impossible that there could be bribes paid. And
wait. The standard impossible?
Improbable, inherently improbable. Your Honor, it happened before with regard to that precise concession just a few years earlier. So our position, it's not inherently improbable that those could have been bribes.
Well, the question is, let's use Lorenz. Is there objective reasons to doubt the story? And you're back to the problem that you have zero evidence connecting Exxon to these payments. Zero. They take place after the deal is finished. You have zero evidence to indicate that Exxon even knew about the bonus payments.
That's correct, Your Honor, and the report says as much. I'm not going to dispute that. That's true.
Yeah, but that seems to me that undercuts enormously your defense on actual malice.
Okay, let me make sure that my colleagues don't have further questions.
I just have one question on the anti-SLAPP issue. I'm sorry to take a little bit further, but I'd just like the counsel to give us, on the anti-SLAPP issue, could you, the DC Court of Appeals opinion that came out after the briefs were filed, read in that case? Why doesn't that totally resolve this question of the applicability of the anti-SLAPP statute? Because it makes clear that discovery is virtually impossible.
As I read Mann, Your Honor,
I asked you about Fred. I asked you about the new decision.
Yes, Your Honor. I'm just explaining how that led into the Friedman versus Orbis intelligence case. Yeah. The standard for both Mann and Orbis is to avoid the conflict with the federal rules or constitutional issues. The standard, the likely to succeed on the merits, is that the plaintiff can't succeed as a matter of law. It's equivalent to 12 or 56. In most anti-SLAPP cases, the defendants will offer evidence, and it will be the equivalent of a Rule 56 motion, which under Rule 56, in early Rule 56 motion, the respondent can explain that it needs discovery. In our case, is a little bit different. We moved to dismiss under Rule 12b6 for failure to state a claim, and no discovery was necessary. But I think if a claim is insufficient as a matter of law under Rule 12b6, it can't be likely to succeed on the merits because the claimant cannot prevail as a matter of law under Mann and under Orbis. I agree with you. In Friedman, the case was treated essentially like a Rule 56 based on evidence, but I don't think that's the way that an anti-SLAPP motion needs to be treated.
Can I just ask you about the way this issue gets teed up? Because there's an appeal, there's a cross appeal, there's the underlying question of whether there's actual malice, and there's the anti-SLAPP issue. So there's a number of ways that we can do the decision tree. But let's just suppose, I know you're going to resist this, but let's just suppose that on the appeal, that the decision is made to send it back on actual malice because the Court of Appeals concludes that there's enough to get past the pleadings, at least on actual malice. Not that anybody's going to get home, but that there's enough to get past the pleadings. Then is there still a need to address the anti-SLAPP issue? And I guess your argument would be, I'm thinking your argument would be, but correct me if I'm wrong, there would be, because if the anti-SLAPP statute does apply, then that would impose a greater evidentiary burden on the plaintiffs. And if it did impose a greater evidentiary burden on the plaintiffs, then they might not have met that burden, even if they met normal 12b6. And if they haven't met the anti-SLAPP burden and the anti-SLAPP provision does apply, then you still win at the pleading stage. Is that what you would say? Or am I not understanding your argument?
Your Honor, I don't believe so. I believe our argument in the district court was that the anti-SLAPP motion we prevailed on for the same reasons as the 12b6. So we were aligning the standards under the federal rules with the anti-SLAPP. I believe if the court were to say that the motion to dismiss was denied, given that the anti-SLAPP on its merits incorporated the arguments of the motion to dismiss, I think that the anti-SLAPP is denied as well.
Because you're more beholden to the position that anti-SLAPP didn't do anything than you are to the position that you want to get something extra out of the anti-SLAPP.
I think that Abbas forecloses getting something extra out of the anti-SLAPP case, Your Honor. I think that for the anti-SLAPP statute to apply in federal court, the standards need to be in alignment with Rule 12 or Rule 56. We didn't bring a Rule 56 anti-SLAPP motion. We brought a Rule 12 anti-SLAPP motion.
Okay. All right. Let me make sure my colleagues don't have further questions at this point.
No.
Okay.
No.
Thank you. Mr. Smolla, why don't we give you 3 minutes for your rebuttal?
Thank you, Your Honors. And first, just very quickly on the anti-SLAPP, I think that the dialogue that we've just heard resolves the case in our favor because they can't have it both ways. And to the extent that it applies automatically, it imposes more procedural burdens on us than we would otherwise have. I want to just turn to the merits. And again, I don't think I need to be very long because the dialogue between the court and Mr. Bowman and the dialogue between the court and me have already, I think, eliminated the pivotal issue. So I'd just like to connect the dots in a few ways. First, there is an interconnectedness between the underlying falsity issue. Did this allege bribery? Would a reader come away from this thinking they are saying these folks took bribes? There's an inherent interconnectedness between that issue and the actual malice issue. And you saw it revealed constantly when pressed. Mr. Bowman would constantly fall back on all we were doing was asking questions, all we were doing was calling for an investigation. And as I have conceded to Chief Judge Srinivasan, if that is all they were doing, we don't have a case. But the district court found that was not all they were doing. And when you read the report, I'm sure the court will say it is at least very plausible that's not all they were doing, that they were affirmatively making the case, this is a bribe, this is a bribe, this is a bribe. And yet, as you've already seen revealed, juxtaposed with that is obvious reasons to doubt. And the last thing I want to say, that remember, we don't have to prove the obvious reasons to doubt. At this stage, we just have to have plausible allegations of obvious reasons to doubt. And as the quoted sections from our brief reveal in the dialogue between Judge Silberman and Mr. Bowman, our hypothesis is they have essentially conceded they have obvious reasons to doubt. They say so essentially in the text. And given that, this case should move forward into discovery. Thank you, Your Honors.
Can I ask just one question, just a factual one? So there's a letter that has the language that Judge Silberman was quoting. I just want to double check. And it says there's no evidence that Exxon was aware of these payments. Is that in the complaint?
Yes, Your Honor.
And
I think, Your Honor, I don't remember where, but what I will say is that the entire report was incorporated in the complaint, and we rely on the entire report. And so I think that the court can look to anything in the complaint or the report as illuminating obvious reasons to doubt.
Yeah, that may be so. I was just wondering if that particular language was pointed out in the complaint.
Your Honor, I don't. It's a long complaint. I don't remember.
Okay.
Thanks.
All right. Thank you, Mr. Small. Mr. Bowman, since there's a cross appeal, we'll give you rebuttal time too. And why don't you limit the argument on your rebuttal to the cross appeal? And we'll give you.
Yes, Your Honor. Although, may I correct one misstatement I made in response to a question from Judge Silberman?
Yes.
Judge Silberman asked about the public nature of the bonuses. I was mistaken. I'd forgotten. The bonuses were not public until Global Witness revealed them. Global Witness its report was the one that revealed those. So I just wanted to correct that misstatement. On the cross appeal, I think the issue is fairly straightforward, that Mann attempted to reconcile and interpret for the first time the standard for prevailing on the anti-SLAPP statute. which was the precise issue that Abbas found conflicted with the federal rules. Mann clearly said, we find that it comports with the federal rules. Given that there's now alignment between the substantive standard to dismiss a case prior to trial, there is not the same conflict that existed.
I don't understand how there's alignment, because under Mann itself and under the subsequent case, but even under Mann itself, there still needs to be some evidence. And usually under 12b-6, there's just not.
Right. And that, Your Honor, is the distinction between a Rule 12 motion and a Rule 56 motion. I mean, certainly, if you're going to bring a type of anti-SLAPP motion to put forward evidence, then it's essentially now treated as a Rule 56 motion, and the defendant has to prove there's no disputed material fact. It would be an odd outcome to have a statute aimed at protecting speakers like Global Witness, speakers that have been dragged into litigation and exposed to the expense and harassment of litigation on matters of public concern one too early. And so our position is that a Rule 12 motion, as a matter of law, you don't have to get to Rule 56. If a complaint can't survive Rule 12, it also doesn't survive Rule 56, and therefore the complainant isn't likely to succeed on that on that motion.
There's a different standard. As I understand the D.C. Court of Appeals decisions, you have to do more to get past a Rule 12 motion in D.C. court than you would in federal court under the anti-SLAPP statute. And if that's true, then when it gets in federal court, the federal rules trump the anti-SLAPP statute.
It's true, Your Honor, you have to do more than a motion to dismiss in state court if you rely on evidence. But those procedural rules of a motion to dismiss don't apply in federal court. You only have Rule 12 or 56. And our position is that you can't be likely to succeed on the merits, as the Mann case said, where a claimant could not prevail as a matter of law if you can't state a claim under Rule 12 as a matter of law.
Okay. All right. If my colleagues don't have any further questions at this point, Mr. Bowman, Mr. Smola, thank you for your arguments. The case is submitted.
Thank you, Your Honor.
Thank you, Your Honor.
Case number 19-1164 et al. COMPTEL, doing business as Encompass petitioner versus Federal Communications Commission and United States of America. Mr. Murray for petitioner COMPTEL, Mr. Gallardo for petitioner California Public Utilities Commission, Ms. Sundarasan for the respondent, Ms. Cooper for the intervener.
Morning, Mr. Murray. When you're ready, please proceed.
Morning, Your Honors. May it please the Court. David Murray for petitioner Encompass and its members. Our challenge is limited to the Commission's grant of nationwide forbearance from avoided cost resale under Section 251C4 for time division multiplexing lines, or TDM, purchased by government and business customers.
Would you please explain something for me?
Yes, sir.
What is the relationship between TDM, which I'm not sure I thoroughly understand, and copper wires, copper loops?
TDM is delivered over copper loops, Your Honor, and the distinctive feature.
What is TDM?
It's a business type of line that's used, but it's a DSO line. It's the same line that would be used for voice in your home.
It's a line.
Yes, it's a physical line. It's a copper loop that goes to the house, and it's lined.
But as I read the brief, it doesn't have to be copper.
No, Your Honor, it can be offered over fiber, but the difference is that the fiber is not line powered. So if your voice service goes out in an electrical outage, you have no voice service.
No, I understood that. So TDM is a method of transmission, and copper wires are a medium of that transmission, not a method.
That's correct, Your Honor. And the record showed there are 28 million of these line-powered copper lines that government and business customers are purchasing. And we compete with ILEX for those 28 million lines. Half of our customers are located in rural areas where the line-powered copper TDM is the only available voice service. And they include local post offices, schools, libraries, first responders, and myriad others where there's no internet broadband and there's no VoIP. Where VoIP is generally available to the other half of our customers, they too purchase line-powered copper lines in addition to VoIP because of that distinctive line-powered feature. And those TDM lines, those line-powered lines, Your Honor, are 3 to 4 times more expensive than VoIP.
Well, don't say TDM lines because you're talking only about copper, aren't you?
I'm talking about the line-powered copper, so I'll try to refer to it that way.
Please don't use TDM then, because it's going to confuse me, because
Okay.
that includes both copper and fiber.
Yes, I will use line-powered copper, Your Honor. And the customers that buy that line copper, in addition to VoIP, there's hundreds of thousands of these customers, and they range from federal and state agencies to banks and retail chains, and they demand them to ensure critical communications, especially given increasingly severe climatic events and blackouts such as in California. In many cases, these line-powered copper loops are mandated by law. For example, they're required for time synchronization of the National Airspace System and as a fail-safe for prescription drug fulfillment by pharmacies and even for daycare centers.
Counsel, may I show you my simple-minded approach to this case? Isn't it fair to say that the legacy LECs are diminishing in their role in the market rapidly?
In certain areas, they are, Your Honor. There's certain.
Let's talk nationally.
Yes.
I've looked at statistics, and there is a dramatic decline in their position in the market as different modes have come in.
That's correct, Your Honor. But where they still maintain a local monopoly is over these copper line-powered loops to business establishments and government agencies. And
well, yes, that's like saying after the automobile came into existence, there is a company that built horse carriages that still had a monopoly.
Well, Your Honor, just because something is old doesn't mean it's not useful. And there are large parts of rural America where the line power copper loop is the only voice service that's available. And
are these non-price cap companies?
No, these include price cap companies. And indeed, Your Honor,
most are non-price cap, right?
No, that's not the case, Your Honor. And in the record, we showed that half of our customers are in rural areas served by price cap LECs. That's why we are able to compete with them using the avoided cost statute. It gives us the opportunity to go in and offer a competitive alternative, and we are the only alternative in those areas.
But go back to my point. Nationally, the LECs are dropping like flies. Their business has dropped in the last, 5 years from 80% to down to 37%. All the other intermodal or other modal groups are killing them, right?
Yes, but what those other intermodal groups cannot offer, Your Honor, is the line-powered feature of copper loops. And, Your Honor, the ILECs have not retired those loops, and they haven't retired them because there's still a very persistent and strong demand. 28 million of these lines are still being sold, and we're competing vigorously for them. And we are the only competitive alternative for those lines, Your Honor. Now, the FCC may want to start drawing different lines, but if you go back to their avoided cost resale orders, in the Terry case, for example, it was one single exchange serving 605 households. In the Omaha order, it was 24 wire centers in the Omaha MSA. So the number is not necessarily dispositive here, even though it's a very nationwide, strong, persistent demand for these line-powered copper loops. And what this commission did
isn't it diminishing?
No. The record showed that the demand for these line-powered copper loops is persistent, and in fact, with recent climatic events and the rolling blackouts you're seeing in California, they may become even more valuable. But never before this order, Your Honor, has the commission looked at the retirement of these copper loops as having anything to do with what they claim is the purpose for the forbearance, which is to promote next generation deployment. And that theory, Your Honor, counters 20 years of FCC precedent, starting with the local competition order of '96, all the way through to a 2015 order involving U.S. Telecom petition, where the commission has said the top-down pricing methodology of avoided cost resale imposes none of the costs or burdens that would, it's neutral as to whether or not it has any effect on facilities-based deployment. This decision turns that on its head, and it does so without acknowledging it. And Your Honor,
well, I thought the order did acknowledge it was going to force the CLECs to develop their own facilities and be more effective competitors.
Yes, but Your Honor, first of all, it's not economically feasible, and Congress did not intend in the '96 Act for CLECs to be replicating legacy copper loops when it's wasteful. But secondly, even if we deploy fiber, even if we deploy our own facilities for next generation networks, there is no technology today that has the line-powered feature of the copper loop. As I said earlier, it may be old, but it's still very useful. And as long as that market persists, the Commission has in the past recognized that there's an importance of having a competitive alternative for that service. And we have been the only competitive alternative, and the only way we've been able to do that is through avoided cost resale.
Because you know, but excuse me.
It's okay. Go ahead. No, go ahead.
No, David, go ahead. Sorry.
Why don't you finish? I didn't mean to interrupt you, Larry. Go ahead and finish your question.
I didn't mean to interrupt you.
Oh, so let me make sure. I have a question that's very similar to Judge Silberman's question, and I just want to make sure I understand this. Isn't it true line power copper loops will remain available, correct?
Yes. Although
it's a question. There's two. Well, go ahead and finish. Yeah.
Well, as you say, the Commission notes, I think it's in footnote 51 or 52, that that ILECs can retire the copper loops, but they haven't.
Yeah, but they haven't done that yet.
That's
and
correct.
As long as they don't, they remain available. So I have two questions about that. Number one, so what your concern is really about then is price, correct?
Correct.
That's what this is all about. And the Commission says, well, price is not a concern because, there's always 201 and 202 to ensure prices are reasonable. And we think, facilities-based alternatives will keep the prices down, right? That's
yes.
an argument. So what's wrong with that argument?
Well, in the areas where the ILECs have the line-powered copper loops, and there is no broadband, and these are a lot of areas in the country. If you look at the FCC's 2018 second wireline order, issued the year before this order, the Commission rejected suggestions that broadband VoIP is a substitute for line-powered copper loops, precisely because there's large rural areas in the country that don't have broadband, they don't have access to VoIP. And Judge Tatel, on the same day that this order was issued, the Commission launched an initiative, a multi-billion-dollar 10-year initiative to try to bring more deployment of fiber and broadband into rural areas of the country. And some of that money is going to U.S. Telecom members like Verizon, like Frontier, like Consolidated, And that is because they are serving areas where our customers exist, where these loops are solely in their control, and the only means that we have to discipline price is through the ability to get avoided cost resale. And we get that either through invoking the discount itself, or as Congress intended under 252A1, to do it through negotiated wholesale agreements. But we only get those agreements if that backstop of avoided cost resale remains in place. And Your Honor, we put into the record that, and this was a November 2018 submission, that when the ILECs filed their petition, they stopped negotiating with our petitioners for avoided recost contracts. And as a consequence of that, and they've continued to not negotiate with us through the 6-month transition period. And because these contracts are typically only 2 or 3 years, the years are expired or they're about to sunset. And
Counsel, if I may follow up on Tatel.
You mentioned this is the last part of this. All right, well, just the last question. In your opening comments and in your brief, you mentioned the risk of the forbearance to the air traffic control system.
Yes.
Could you? So, are there air traffic control facilities in areas of the country where there is no broadband?
There are, and also, Your Honor, it's mandated by federal law that these copper loops be maintained as fail-safes for time synchronization of the national airspace.
Well, did the FAA complain? Did they file comments on this rulemaking?
I don't recall, Your Honor. I mean, we have been vigorous.
I thought to myself when I read your brief, well, if there's a risk to air traffic control, one would expect the FAA to have raised its concerns with the FCC, but I couldn't find it.
Well, I think, Your Honor, that the difference here is it's not that the lines won't still be available to them, but they will now have only one option for purchasing those lines. And that's
my point. That's my point. Wouldn't the FAA have worried about that? Wouldn't that have been of concern to the FAA?
Well, they are a customer, Your Honor, of our clients, and we have been representing their interests both before the FCC and now in this appeal.
Counsel, may I follow up on Judge Tatel's question? If I understand your concern, is the possibility that copper wires, which are diminishing in use, but they're still in existence, will be increased in price to you. That's your objection, isn't it?
Well, they'll be increased to the point where we can no longer compete, Your Honor, because the critical price, and this was what the FCC noted in its Omaha order, that the 251B1 general resale option is not an adequate protection because the only way that CLECs can compete for these copper loops is on the basis of price. And without a wholesale discount, you can't do that. So it will drive our petitioners out of business.
Why should we care whether the price is increased to you? Isn't the concern that underlying the original statute as it's been implemented over the years, the concern is competitiveness vis-a-vis consumers? And the more fiber and voice-over develops as a technique, the LECs are having a decreasing percentage of the market. They're weaker and weaker and weaker. Why should we care? Why should there be any relevance to the fact that you may have to pay more for copper wire access?
Well, Your Honor, I think the reason you should care is because while the FCC has been given broad discretion under the Section 10 factors for forbearance, the one thing that this court has said in the Verizon v. FCC 2009 order, and I believe earlier, and I think even a decision in which you were involved, Your Honor, and may have written the opinion, the one thing they can't do is deviate from their past decisions without explanation. And in this case, Your Honor, up until this order, the Commission has looked at each market. It has looked at avoided cost resale. It has looked at the top-down pricing of avoided cost resale, and it has said it doesn't affect.
Is that basically your geographical market power argument?
It's not just that, Your Honor. You will not find anywhere in this order a discussion of the top-down pricing of avoided cost resale. They lump avoided cost resale and UNEs into the same analysis, and that's a critical distinction because the pricing methodology for those two requirements are fundamentally different.
You're going far removed. Let me put this.
I'm sorry.
I tried to read the brief carefully. What is your core legal argument?
Our
core. Do everything kitchen sink in your brief, which is well written, but it's everything in the kitchen sink. What is your core legal argument?
Our core legal argument, Your Honor, is that for the last 20 years, the Commission has recognized that avoided cost resale does not impose the types of costs on ILECs that have any influence on their decisions to deploy next generation networks. In this decision, for the first time, the FCC has said that avoided cost resale does affect the incentives of ILECs and whether or not they will deploy next generation networks. And there's no explanation for that. And the reason in the past, Your Honor, that the FCC has said that this doesn't affect facilities-based deployment is because of the pricing methodology. It's fundamentally different from the cost-based pricing for UNEs. There's no discussion of that in this order. I'm sorry.
I understood the focus of the FCC's decision to be inducing the CLECs to go into more advanced facility-based transmission mechanisms.
And we are doing that, Your Honor. And
No, stop for a second. Mm-hmm. Isn't it fair to say that the thrust of the order will push the CLECs into their own facilities-based operations, which of course would be fiber and other voice over?
I can assure you, Your Honor, that CLECs are going into facilities-based competition. The one thing they're not doing, they're not going out and replicating copper loops that were deployed decades ago. The costs were recovered decades ago. It's not efficient. And so the question becomes, from the customer perspective and from the competitive perspective, which is what Congress cared about under the 96 Act, if we eliminate avoided cost resale, are we leaving markets where there is only one game in town, the ILEC? And that is what this order does. It restores local monopoly conditions for these services in large swaths of the country.
And if isn't really this a fight between what is predicted down the line, where we would really have to defer to the FCC because predictions are laden with policy concerns, very difficult for courts to challenge agencies with respect to their predictions.
But predictions have...
They're predicting the decline of copper loops.
They may be predicting it, Your Honor, but there's nothing in the record to support that prediction. And there is contrary evidence that these 28 million copper loops have not been retired. There's nothing stopping the ILECs from retiring them. They're not going to retire them because there's still this very significant demand by these business and government customers. And if anything, this forbearance order is going to reduce the incentive for ILECs to retire those copper lines. And that is record evidence that the Commission overlooked, disregarded, but whatever, you won't find it in the order.
Okay, if there's no questions at this time, we'll make sure there's not, then we will hear from you a bit on rebuttal, Mr. Murray.
Thank you.
Mr. Gallardo.
Thank you. Good morning, Your Honors. May it please the Court, I am Enrique Gallardo, representing Petitioner, California Public Utilities Commission. I'll discuss several ways in which the FCC was arbitrary and capricious in approving forbearance for the incumbent local exchange carrier obligations to unbundle their network elements and to offer services at avoided cost. And to the first point regarding public safety, Your Honors, as we speak, much of the western United States is on fire. This year, California wildfires have destroyed many more acres than in any other year in history, and we are not even done with the fire season. Other states face increasing challenges from hurricane storms and other climate-related emergencies. The resiliency of communications during such emergencies is only going to grow in importance. First responder agencies depend on the resiliency of line-powered time vision multiplexing service delivered over copper loops, obtained through the unbundling obligation to maintain communications during emergencies. Moreover, the 911 calling system in many regions currently depends on these network elements obtained through the unbundling obligation.
Excuse me, counsel, did I not see in the record some indication that the California authorities were no longer of the view that copper wire would be that important?
No, Your Honor, that was not in the record. That was in the respondent's briefs, or it might have been the intervener's briefs, but not in the record. And of course, we should view this case on the record, but that was not in the record. That was in the brief. Thank you, Your Honor.
So, counsel, let me just ask you a question. I thought your brief on this point was quite powerful. I'm going to ask the Commission some questions about it. But let's assume we agreed with you that the Commission's response in its order, as opposed to its brief, on this public safety question was inadequate and it has to go back. What is your position going to be on remand? I mean, as I understand it, TDM copper will remain available for public safety agencies, correct?
In some cases, yes.
Well, where won't it? It's required, right? There's no indication at this point that it won't be available everywhere in the country, is there?
It's hard to say, Your Honor. I mean, the ILECs are free to switch from copper to retire their copper.
Okay, but at this point they haven't, right? So in this record they haven't done that. They're offering copper TDM, and as long as they offer it, they have to offer it, right? Right? So same question I asked COMPTEL, is this basically a concern about price? Is that what it is?
I think it's also a concern about availability. There's concern that it may not be.
Just explain that to me, would you please?
Well, the unbundling obligation requires dialects to make this available. Without that obligation, I don't believe there's anything that would ultimately require this to be available. I mean,
whether just to be clear on this point, whether it's available or not is not a byproduct of this order. There's going to be independent decisions that determine whether it's available or not. There may be legal requirements that remain available, but this order itself goes to the market, goes to the price, right? It's not directly impacting availability.
It impacts availability in the sense that there's no obligation to offer this service without the unbundling obligation, I believe.
Wait a minute, counsel. I think both my colleagues are pointing out that there's a separate order that sets forth the conditions whereby LECs can abandon copper wires, right?
Yes, Your Honor.
And there's nothing in this order or any order that requires LECs to maintain copper wires.
No, correct, Your Honor.
So I think we're all puzzled as to why you think this order is the order that reduces the availability of copper wires.
Well, again, as I mentioned, it does reduce availability in terms of limiting the obligation to offer this, to unbundle the element.
Wait, now you completely confused me, because I thought you said that, I thought you agreed with Judge Silberman's point that there isn't anything that requires it, and that this requires a provision of TDM copper, and that this order doesn't deal with that issue. This order simply deals with eliminating the unbundling requirement, not the provision of TDM copper itself. Right?
Yes, Your Honor.
What am I missing? Yes,
Yes.
what?
We're saying the unbundling obligation is the means by which customers, government customers, business customers that rely on the resiliency of line-powered copper lines, that's the medium by which they get this service. So I understand what you're saying is that the lines, whether they exist or not, is another issue.
Right.
But this issue is whether or not the incumbent carriers are obligated to offer the service, and the elimination of the service.
This gets back to both of my colleagues saying this is just an issue of price.
Price and availability. I mean, yes.
Just to be clear, when you say availability, you're talking about availability of unbundled service, not availability of copper. I mean, in other words, as I understand the situation, whether copper is available or not, and I'm just using copper loosely, I'm sure that I'm getting the actual particulars wrong, but I think everybody understands what I'm getting at. That the availability of copper is settled by something else. What you're talking about is whether there's an unbundled availability, and yeah, that's affected by this order. But there's only an unbundled availability of copper if there's an availability of copper to begin with.
Right.
That's governed by something else outside this case.
Yes, Your Honor. Yes, that is true.
Okay.
But I just want to make sure your position is also, I think, as I read your brief, that the orders, as you call it, one sentence response to this whole concern was simply not responsive, correct? That it didn't even deal with price, right?
The order did not address public safety at all. There was one sentence that might have tangentially touched on issues of 911 service, but on wider issues of public safety, many issues of public safety that were raised by parties, the FCC simply did not provide any response. And that is last year in the Mozilla Corporation versus FCC case, this court clearly stated that public safety was a fundamental responsibility of the FCC, and the FCC must address the impact of its orders on public safety. And the FCC did not do this here. So we believe that's arbitrary and capricious.
Judge Silberman, Judge Tatel, do you have further questions for Mr. Gallardo?
No, I don't.
No.
Thank you, Mr. Gallardo. We'll give you a little bit of rebuttal time too.
Sure.
Ms. Sundaresan.
Good morning, and may it please the court. My name is Saila Sundaresan, and I represent the Federal Communications Commission and the United States. The issue before this court is whether the commission...
Could you, counsel, I'm sorry, but your time is limited. Could you pick up right away on this public safety question?
Wait a minute. Just lost everything.
Pardon me?
Judge Silberman, we can still hear you, and now we see you. You're still there.
Okay. I don't know what you do.
That's because, Larry, your problem is you don't have line powered copper. You're using.
Oh, I think it's counsel. As soon as counsel started to talk, I lost my picture.
We've got you back.
That's her fault.
All right. I was just asking counsel she could just begin with the issue we just finished on with California in this question of public safety.
Yes, Your Honor.
Their argument, let me just say, their argument is that the commission just had one sentence in its entire order on this issue, and that it wasn't responsive. It mentioned only 911 service. It wasn't responsive to any of their other concerns. And as they point out, the commission in its brief says that it didn't have to do more because the public safety comments were redundant of other comments that the commission had considered. And as they point out, that's not an acceptable response after our decision a few years ago in Missouri. That's their argument.
Your Honor, the commission, the CPUC's central public safety argument is that line power TDM over copper is essential for government customers and public safety agencies. That is the availability of line power, and the line power argument was addressed by the Commission in paragraph 32 of the order. And the Commission was not convinced by that argument because it found that businesses that rely on continuously powered communications routinely purchase backup power. And as this court hit on with our opposing counsel, this order, the availability of line power is tied to the existence of copper. And incumbents increasingly are retiring their copper loops, and this order has nothing to do with that. That is a business decision that the carriers are increasingly making in response to dwindling customer demand for TDM over copper. And so the line-powered argument, yes, petitioners can claim that their customers want line power, but the market has dramatically shifted over the last 25 years. And as customers are increasingly gravitating...
You're relying on which paragraph? Is it 32?
Yes, Your Honor.
And I just want to make sure I'm looking at the right place. Is that JA 277?
I believe that's correct, Your Honor.
So that's talking about the distinctive line power feature of TDM voice service and is making the point that it's available, but it doesn't deal with public safety as such, right? It doesn't deal with public safety by terms. And so then it seems like the question would be, well, even if there is a bare availability, there could still be a public safety implication from the order. And the argument is, well, under Mozilla, you may well be able to establish that the public safety is accounted for. I'm not suggesting that you can't account for that, but I'm just talking about the four corners of the order itself. It needs to treat with the question and deal with it.
Your Honor, the reason that there is not a standalone public safety analysis in the order, because this order has nothing to do with the availability of TDM service, which will continue so long as incumbents have not retired their copper loops. TDM over copper will continue to remain available. This order, as the judges had hit on earlier, is about ending regulated pricing to the analog loops and resale. And CPUC does not challenge the pricing as it relates to the Commission's grant of forbearance from these requirements. So nothing in this order is ending the availability of the TDM service itself. As the record confirms, several incumbents have filed comments with the agency saying that they have strong business incentives to continue to offer TDM to those customers who want it. This order simply ends the pricing aspect.
Counsel, I'm looking at, I think I'm looking at Joint Appendix 401 and 402, California's comments. They're raising concerns about 911 network availability and cost. They specifically mention cost.
My recollection of their actual brief is that they're not challenging the
I'm talking
pricing.
about their comments. I'm talking about their comments before the Commission.
Your Honor, the Commission did say in the order that there is no difference in the reliability between VoIP 911 service versus legacy 911 service. And in any event, as we explained in our brief,
but is it, by the way, isn't that's inherently, that makes no sense to me in terms of reliability. I mean, the Commission itself acknowledges that that for VoIP and other non-copper wire services, you need either battery or generator backup. And so the reliability question turns completely on the adequacy of that backup, doesn't it?
Is driven in part by the backup, yes, but CPUC's argument that they're...
It's not in part, it's completely. I mean, that's what the line power issue is all about. I mean, you know, I'm participating in this argument here today in rural Virginia, and we're using an internet-based service, but we're getting a storm here in a few minutes, and if my power goes out, I'm going to have to switch to the telephone. And how long I could stay on this depends on what kind of generator backup I have. So they're not separate. They're very integral to each other. It just doesn't make sense to me that the commission could say that the services are equally reliable. That can't be right.
Your Honor, that argument is supported by the fact that California is currently in the process of transitioning their legacy 911 system to an IP-based 911 system in order to enhance public safety, not undermine it. The leading state agency in California that is overseeing emergency preparedness has said that an IP-based 911 system is in fact more reliable, has less power issues, and has more monitoring capabilities than the existing legacy 911 system. And it's not just California. 30 plus states around the country are also following suit. So the trend is very clear that CPUC's argument that a TDM over copper is essential for 911 is directly contradicted by what California is currently doing. And CPUC doesn't challenge the accuracy.
Counsel, excuse me, that's the point I made earlier. The response was, although that's in the brief, it's not in the order.
Your Honor, we did speak about the facilities-based or VoIP-based 911 being similar in terms of reliability as the legacy-based 911. That is in the order. With respect to our argument in the brief, we raised that to essentially impeach CPUC's claim that California is so reliant on legacy TDM for their 911 system. That is absolutely not true. That is contradicted by what California is doing right at this moment. In fact, they have since targeted March 2021, only 6 months away, as the date in which they plan to complete the implementation of IP-based 911 infrastructure throughout the state of California. So California is not in the infancy stages of transitioning to an IP-based 911 system. It is almost near completion.
I thought that was a very important point. As a matter of it, one of the things that's interesting about the FCC is you keep referring to regulations as orders, when under APA, of course, an order is an adjudication. And Chenery, which is relied on constantly by the parties and by the petitioners in this case, really has a different kind of meaning in regulation than it does in adjudication. And so you're only required in regulation to respond to the most important questions, not to every question. And you can respond in your brief to issues that are more less significant. Is this, was this issue, do you think, a particular significant point, or one that you can respond to in your brief to attack the argument made by petitioner?
Yes, we are permitted to respond to it in our brief because we were essentially impeaching CPUC's claim. They are contending that the legacy TDM is so essential for 911, and that is contradicted by what the state is doing right at this moment.
That's a very powerful point. Why wasn't it in the order? Or did you not have to have it in the order?
The commission didn't. The commission did talk about the VoIP 911 and legacy 911 as being very similar. We also addressed the line power argument in paragraph 32. In footnote 116,
you did say that everybody was moving to fiber away from copper, including for 911.
That's right, Your Honor. Our larger point is that the market has changed dramatically. The reasons why these mandates were enacted a quarter century ago was to jumpstart competition in the local telephone market. That purpose has now been achieved. Competition in this market is flourishing. Customers are not interested in TDM over copper.
Actually, I'm sort of struck by the fact that the LECs look like the weak sisters in the market now, hardly the monopolists.
Yes, that's true, Your Honor.
They're being killed by various other competitors in the market that weren't even visualized in 1996.
That's exactly right. Today in the voice services market, there are cable providers, over-the-top providers, wireless providers, CLECs, incumbents. So customers have an access to any number of options, which will help discipline rates. And the fact of the matter is that these regulations were enacted to promote competition, which has been achieved at this point. And these mandates were never intended to exist in perpetuity. And we know this because Congress gave the Commission the authority to forbear from these regulations once they were no longer needed. And this order is not even taking away the availability of the TDM. I can't emphasize that enough. The record confirms that incumbents are committed to providing TDM for those customers who want it. We also said in footnote 124 of the order that we expect that carriers serving government customers will make sufficient arrangements to ensure that those customers are continuing to receive service. This order simply ends regulated pricing.
Counsel, you have to let me interrupt. That's part of the rules of appellate advocacy.
I'm sorry, Your
there is one, it seems to me, one weakness in your case. You argue, and the order argues, that if they didn't forbear on these regulations, both regulations, both the top-down wholesale and the what do we call it, UNE?
Analog loop.
The continuing loop, or the sale of the loop. That if you didn't forbear, that the LECs would be trapped in having to continue to operate copper loops. That's clearly wrong, isn't it? And footnote 52 in your order acknowledges it. That's phonier than a $4 bill.
Your Honor, it is true that the incumbents can retire their copper loops. That's a decision they make and not the Commission.
Question, how are they trapped by the existing regulations? When, as we pointed out in a dialogue earlier, nothing stops the LECs from retiring their copper loops. So why are they trapped?
So the way they are, I'm not sure the words they use, trapped, but the reason that we said that in the order.
That was your word. That was in your order.
Your Honor, if it was in the order, then I misspoke. The reason why the incumbents are in the position that they are is because while it is true that they can retire their copper loops, they don't do so on a customer by customer or line by line basis. They do it in a given geographic area. And if they have existing business customers, and this order, and the petitioners are talking about business customers here, we're not talking about residential customers. Those business customers, the incumbents have multi-year contracts with those customers. And of course, business customers tend to produce or purchase larger volumes of service. So the incumbents are simply not going to just retire the copper loop and risk disrupting those customers' operations. So the incumbent will, of course, do everything they can to transition those customers to IP-based voice services. But until that happens, they are still maintaining the cost of the copper. And as long as they have the copper, the CLECs can then continue to lease the analog loops at highly discounted rates and to purchase the telecommunications services through avoided cost resale at a highly discounted wholesale price.
Counselor, that doesn't mean that the LECs are trapped in any way. They can go out of the copper wire business anytime they want.
Your Honor, the Commission also found that these regulations created a...
Counsel, isn't that true?
Your Honor...
Yes or no? Yes or no? Isn't it true that you're not at all trapped by the continuation of the regulation? The LECs can go out of the copper wire business anytime they want. There's a separate regulation on that.
Yes, they can retire their copper loops and lose those customers. Of course, they don't want to do that.
Well, that's what the claim was. The existing regulation before forbearance trapped them. And I think that's baloney, isn't it true?
Your Honor, you are correct that the incumbents can retire their copper loops when they want to. The Commission also pointed out, though, that these legacy regulations prolong the dependence on these legacy networks, and that the reason for that is because the CLECs...
Wait a minute, not on the part of the LECs.
On the part of the CLECs, Your Honor. So the competitive...
I can understand the arguments with CLECs. I can understand the argument that the agency puts forward. We want to push the CLECs into the modern world to be more effective competitors. I don't understand, and I think it's fallacious, is the point you make in the regulation that the LECs are trapped by the existing rules, because nothing traps them. They can go out of the copper to wire business anytime they want.
They can retire their copper loops when they want to. My explanation was that...
You concede that footnote 52 eliminates the contention in the body that the LECs are trapped in some kind of way by the existing regulation?
Your Honor,
would you concede that, counsel?
We would concede that the stronger argument is that the CLECs are they are less incentivized to deploy their own facilities.
Would you concede that that's a baloney statement in the order?
We concede that the incumbents are not precluded from retiring their copper and can transition to fiber. Yeah.
Therefore, if the FCC used the statement that the LECs are trapped by the existing regulations, that was false.
Your Honor, the reason we said that is just because as long as they do maintain their copper, and it's not a process that is instantaneous, right? So,
you know what I call this argument you're trying to make? If my aunt had wheels, she'd be a trolley car. Did you ever hear that? Well, that's too old.
I can't say that I have, Your Honor, but we certainly concede that the incumbents can retire their copper loops, but and
see that they're not trapped.
They're not trapped.
Thank you.
So
now,
Larry, no, go ahead.
I'm sorry. When you write a long order like this, a regulation, you can make a mistake which isn't necessarily fatal. But it's important at oral argument to acknowledge when you make a mistake.
Yes, Your Honor.
Excuse me, David, go ahead. You're older than I am.
I beg your pardon.
Tatel, you had a question?
So yeah, I have a question. It relates to the cost question, and specifically to the Commission's 10A1 response on reasonable prices. So the Commission gave two reasons why it thinks forbearance will not result in unreasonable prices. One was, 201 and 202 and the other provisions are still in the statute. That's one. And number two, that facilities-based competition will continue to discipline prices, right? That's its answer for that, right?
Yes.
So I have two questions. So first of all, on the 201 and 202 point, if the Commission can satisfy 10A1 by simply pointing to the existence of 201 and 202, why did Congress bother putting 10A1 into the statute? In other words, if 201 and 202 are adequate, why did Congress require the Commission to affirmatively find that forbearance will not result in unreasonable rates?
And perhaps as an additional statutory measure to ensure that rates remain just and reasonable.
Well, the Congress knows the 201 and 202 are in there, right?
Right.
They know that. Congress knows that, but yet it required the Commission to make this affirmative finding, and so therefore I have to find where that finding is. And the only thing I can find is the argument that facilities-based services will discipline the market, right? That's what it is, correct?
Yes, Your Honor, and
okay. And the problem with that isn't Quest Phoenix the problem with that, because as the petitioner points out, in Quest Phoenix, the Commission expressly found that forbearance from UNE loops will not encourage the deployment of next generation services. It's just the opposite.
Your Honor, it is true that.
So,
I'm sorry. Go. Please finish.
So let me just finish. Let me just crystallize my question then. Okay. So my question is, to sum up, is as I understand the statute, relying on 201 and 202 isn't enough. There has to be, as you said yourself, an affirmative finding that forbearance will not result. And the affirmative finding that the Commission has made is inconsistent with Quest Phoenix, which isn't explained in the order. You do talk about it in the brief, but not in the order.
Your Honor,
Yes,
Your Honor. So 5 years after Quest Phoenix in the U.S. Telecom, 2015 U.S. Telecom Forbearance Order, the Commission actually explicitly said that these legacy regulations, in fact, decrease investments in next generation facilities. That is a far more recent decision than the Quest Phoenix order. In any event, this court has disavowed the notion that legacy regulations somehow increase investments in next generation facilities. In USTA 1, back in 2002, this court said that legacy regulations deter investments in next generation facilities because it limits the resources that the incumbents have to invest in next generation services, and it decreases the incentives for the CLECs to invest in next generation services because it's much more financially advantageous for them to simply rely on the discounted rates that they receive.
Right. I get all that, but where do I find any of this that you're now giving me in the order?
The order did not explicitly acknowledge that finding in Quest Phoenix.
I'm sorry. You could delete the word explicit. It didn't acknowledge it, did it?
The order didn't acknowledge the Quest Phoenix finding. The Commission did make the larger point that the market has changed dramatically. Customers have switched to IP-based services, that the Commission, under Section 706 of the Act, is encouraged to promote advanced telecommunications deployment, and that these regulations slowed the transition to IP-based services.
Counsel, wasn't Quest Phoenix a request for forbearance in a specific market in Phoenix?
That's exactly.
Whereas this rule that you've called an order, as a former administrative law professor, I bridle at calling a regulation an order. But in any event, in this rule, you're dealing with nationwide rather than individual geographical markets. And you've said in, what's it, the Link case, Lincoln, that you're not bound to the analysis of market power when you're dealing with these cases. And market power, as everybody uses the term, refers to local markets, not the national market, right?
That's exactly right, Your Honor.
So the distinction you want to draw, I think, in response to my colleague, is that Phoenix was strictly a local question.
That's right, Your Honor. In Quest Phoenix, Quest was seeking forbearance from the regulation as applied to one market, Phoenix, Arizona. Here, in contrast, U.S. Telecom is seeking forbearance from the regulations for price cap carriers nationwide. And this court, in the Earthlink decision, said that under Section...
That's the case I was trying to remember.
Yes, Your Honor. So under Section 10 of the Act, as this court recognized in Earthlink, there is no particular analytical framework that the Commission is wedded to. The Commission has the discretion to apply a variety of frameworks. Here, we appropriately considered whether these mandates would promote investments in next-generation facilities, because as we found that the market has changed dramatically and customers are overwhelmingly asking for IP-based voice services. The Commission wanted to ensure that providers would be encouraged to deploy next-generation fiber networks to meet this growing demand, and found that these legacy regulations, in fact, impeded the investment in next-generation facilities.
Now, Granite claims their particular business model is jeopardized because what they do is act as an intermediary, sort of bundling together different services from different LECs and selling them at a discount to ultimate big business consumers. And your answer to that is, so what? There's nothing that provides in the statute an obligation to protect your business model. Isn't that correct?
That's exactly right, Judge Silberman. As you had pointed out earlier, Section 10 of the Act is about protecting consumers, the public interest, and competition in general. It's not about protecting individual competitors and their business models. As this court found in USTA 2, even if all CLECs are driven from the market, as long as there is robust intermodal competition from other providers, there's nothing in the Act that prohibits that result. But in any event, the CLECs are not going to be driven from the market because, as the Commission explained, the majority of CLECs are not even relying on these legacy regulations to provide service. They're overwhelmingly providing service through commercial agreements, and that includes Encompass's own members, Granite and Tatel. If you look at page 59 of our brief for that confidential information, you'll see that avoided cost resale constitutes an extremely small percentage of these resellers' business models. They are relying instead on...
Yes, but they are, of course, your opponents argue that that regulation provides a backstop which influences commercial agreements.
Yes, but these avoided cost resale was not created to create a backstop for individual competitors. It was created to promote competition, which is now flourishing in this market nationwide.
That's a good answer.
Thank you, Your Honor.
If my colleagues have no further questions for you, Mrs. Grayson, we'll hear from Ms. Cooper now. Thank you.
Thank you.
Thank you, Your Honor, and may it please the Court. I'd like to pick up with the public safety issues that were addressed earlier today. And what I'd really like to make clear is that nothing about U.S. Telecom's petition or the forbearance granted here could affect public safety, and that's why it isn't addressed at any length in the order. The order has nothing to do with the rules for retiring copper or for discontinuing TDM, and the public safety harms that are alleged to come from those events and those actions aren't germane to this order. In addition, U.S. Telecom explicitly withdrew its request for forbearance regarding 911 databases. The services that governments purchased to receive 911 calls were never within the petition at all because they've never been subject to those obligations. 251c3 has never required incumbents to unbundle the facilities that connect their networks to the 911 call answering centers, and the tariff service of routing those calls has never been subject to C4. In addition, the FCC has also repeatedly concluded that 911 calling does not require copper-based services, and so petitioners' arguments to the contrary are really in the teeth of years and years of FCC orders that have addressed these potential harms and rejected the premise of their argument. In addition, I know a friend at the FCC mentioned that paragraph 32 of the order addresses the line power issue. That is one of the cruxes of the arguments that CPUC makes about the importance of the availability of TDM provided over copper to government customers. The order also does address in paragraph 33 the issue of government customers that will continue to depend on TDM service. And there the Commission stated, which is at JA 278, that marketplace demand is likely to lead providers to meet the needs of customers in connection with technology transitions. Really, all this order is doing is saying that incumbents no longer have to offer these services or lease these facilities at low regulated rates. But where it's economically feasible and sensible for incumbent LECs to offer these services, they absolutely will do so. They have an interest in keeping these customers. Again, as has been discussed today, there's extensive intermodal competition in the marketplace that disciplines end user prices.
Isn't that your key point? The LECs are dropping like flies in terms of the market force they have. And therefore, the notion that they should in any way subsidize the competitive LECs makes no sense when the market is full of competitors that are actually causing the LECs to drop their market share rapidly.
Yes, that's correct, Your Honor. The incumbent LECs was shown in the record, and the order emphasized are now an ever-shrinking share of a very highly competitive marketplace. And right now, under the obligations at issue, we're forced to create systems and maintain systems to handle unbundling and resale that wouldn't exist but for those obligations. And that really puts a thumb on the competitive scale against us. So our more nimble new entrant competitors are able to better compete because we have these one-sided obligations that no other competitors are obligated to pay for.
Thank you, Judge Tatel. Judge Silberman, if you have no further questions for...
No questions. Thanks.
Thank you, Ms. Cooper. Mr. Murray, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. Real quickly, in the 2005 U.S. Telecom order, that was a request for nationwide forbearance, and the Commission denied forbearance from avoided cost resale. In paragraph 60, it emphasized that the top-down pricing methodology effectively caps the prices that ILECs can charge for wholesale voice services, and quote, "We agree with U.S. Telecom that it preserves CLEC's ability to provide voice services to customers without building their own network facilities." And in the second wireline order in 2018, the Commission rejected ILEC suggestions that VoIP is an adequate substitute for TDM or copper lines.
I'm sorry, I didn't hear what you said. What is it?
In the second wireline order in 2018, a year before this order, the Commission rejected ILEC suggestions that VoIP is an adequate substitute for copper loops, especially since VoIP is not even available in many rural areas of the country served by LECs. And here's what the key ruling there was. The forbearance would not promote competitive market conditions because it would eliminate any service alternatives. Your Honor, there is a robust, significant, and continuing demand for these line-powered copper loops by government and business customers. They are consumers.
I'm sorry, I don't think that's crucial. What's crucial is whether there's enormous competition in the marketplace. Why should the LECs be hampered in any way when they're a declining share? They're no longer the monopolist.
Two reasons, Your Honor. Number one, the Commission for 20 years has said that the top-down pricing of avoided cost resale does not hamper incumbent LECs. It has no effect on their incentives. And
well,
secondly,
of course it does.
I'm sorry?
Of course it does.
No, that's the
well, you mean to tell me that the LECs are utterly indifferent to the regulations requiring top-down wholesale? They could charge higher prices. Why should they have an arm around their back? Why should their arms be tied around the back when they're weakening rapidly?
Well, that's my second point, Your Honor. They're not weakening rapidly where they are the sole possessor of the line-powered copper loops used to provide these critical services. And the Commission has found that in the Quest order, for example, Your Honor, Quest got 90% of its retail rate, and that was because it avoided the marketing and the billing and the collection costs. It's not a cost that is radically different from the television pricing.
Doesn't that go back to your argument of it has to be done geographic by geographic?
No,
location?
not at all. The 2015 order was a nationwide request, and the Commission looked at it on a nationwide basis. So, Your Honor, the question is, this is the crux of the issue. The Commission has, up until now, looked at whether or not there is a demand for a service, whether the incumbent LECs have monopoly control over the facilities necessary for that service and there are no adequate substitutes, whether the only form of competition available is avoided cost resale. And in each of those instances, for 20 years, the Commission has kept avoided cost resale and forborne from UNEs.
How can you say they have monopoly control when they're down to 37%?
Well, Your Honor, we're looking at two different things. The market that we care about and that this order ignored was this significant 28 million lines that the ILECs have not retired. They could, they haven't because they don't want to. These are customers that we're competing for with them, and they are the only ones who have these copper loops, and it is not economically feasible for us to replicate them. And Your Honor, you know, Congress, when it enacted the 96 Act, did not want entities to come in and wastefully replicate legacy facilities. It was about promoting next generation networks. And on this issue, avoided cost resale, this Commission for 20 years has said avoided cost resale has no effect on incentives to deploy next generation networks. And that is not even discussed in this order. You will not find the top-down pricing methodology of avoided cost resale anywhere.
Certainly has an impact in encouraging the CLECs to be facilities-based.
Not for copper loops, Your Honor.
No.
Not for copper loops.
It's for alternatives.
And we are building alternatives.
This clearly will induce the CLECs to move more rapidly into more advanced techniques.
There's nothing in the record to support that, Your Honor, and I would say it won't, because if you go back and look at the Omaha order, one of the things that the Commission recognized, the Omaha regulations, the Commission recognized that allowing avoided cost resale creates incentives. We can compete with that even where we have not yet built out our own facilities and next generation networks. And that's a good thing. It provides an alternative. This order is going to restore local monopoly conditions for these 28 million copper loop lines.
Okay. Thank you, Mr. Murray. If my colleagues don't have any further questions, we'll give Mr. Gallardo his rebuttal time, 2 minutes.
Thank you, Your Honor. Continuing on this discussion about competition, the FCC in its order places great emphasis on the role of facilities-based competition, not just competition, but facilities-based competition. Now, the California Public Utilities Commission presented evidence in the record that in California, most of the non-cable CLECs, as well as the 4 large mobile providers, relied on the infrastructure of just one incumbent. So at least in California, there is not facilities-based competition in the voice market, despite the presence of voice alternatives. And other state agencies presented similar situations in their states as well. And the FCC did not address this evidence in its order. I'd like to address some of the discussion that FCC's counsel presented about California's view of the transition of 911 service. Currently, as we speak, the next generation 911 system in California relies on both TDM and voice over internet protocol service. I would question some of her characterization of California's view of 911 service, but I guess the bottom line is because this is not in the record, we can't properly consider this evidence or this information I'm sharing just today. It's not in the record, and we can't properly consider it. And finally, I would point out that the FCC relies greatly on a fundamental factual finding that maintaining incumbent carrier unbundling obligations deters investment in advanced services. Now, this is contradictory to a previous factual finding where the FCC found the opposite. The FCC never discusses this previous factual finding in its order, does not even acknowledge its previous factual finding. And this also is arbitrary.
No, sometimes you refer to factual findings as if they were historical facts when they're really predictions.
Yes, Your Honor, there are predictions of what would happen. The FCC made one prediction previously, and then it contradicts its prediction here, and it doesn't address.
Wouldn't you expect an agency dealing with rapid movement of technology to make mistakes in predictions and to rectify them in future predictions? You're not talking about historical facts. You're talking about predictions.
Yes, Your Honor, but the agency should acknowledge the previous prediction and explain why it's changing its prediction now. And the FCC did not do that.
Is it not sufficient? Is it not sufficient what counsel told us in argument today that Quest Phoenix was a local market issue and this is a nationwide case? In terms of your objection, suppose they just said that in the order. Would you be complaining about it?
Well, I'd have to see what they said in the order and if it properly considered that previous prediction. Now, in terms of the difference between a local market and a nationwide market, I think that's more along the lines of what forbearance test you want to use. But in terms of this prediction of what the obligations will have effect on investment in advanced services, I don't see that distinction matters as much.
You mean whether it's local or nationwide?
Exactly, yes, Your Honor. And if it does, then I would like to see that explanation in the order.
Thank you, counsel. Unless my colleagues have further questions. We'll thank all counsel for their arguments this morning, and we'll take this case under submission.
This honorable court is now adjourned until Tuesday, September 15th at 9:30 a.m.
Goodbye.